again, to everybody who has just joined, a very warm welcome to you all. Just a word on the latest on implementation of the Act, just to make sure everybody's up to speed. So we've recently had an update from Cabinet Office. I think that was the 23rd of February. And I think we're still on track for implementation in October of this year. And we've learned that the regulations that are going to sit under the Act are going to be called the Procurement Regulations 2024. So, of course, we will all need to make sure that we know if we're talking about the Procurement Act 2023 or the Procurement Regulations 2024, or indeed the old regulations, which will continue to be relevant for many years to come. So we're expecting a response on the consultation on the Procurement Regulations 24 by the end of this month. And also we'll start to see that official guidance beginning to feed through from the end of March through to the end of June. We know a little bit more about the central platform as well, and that it's going to do three things. It's going to be the place where we go to do notices, where supplier information is uploaded, and where suppliers can register as well. So FTS is being developed to have all that extra functionality, and I think this is all in a beta test at the moment. So lots to look forward to. Do bookmark our reform page on the procurement portal. We'll be updating all of our materials there. So that's www.procurementportal.com/reform. I think that's probably enough from me. I think first of all, Victoria is going to talk to us about our first question, and that is about this new competitive flexible procedure, which we're all quite interested in. How can we design it, and how can we get the most out of it? Victoria.
Thanks, Jenny. Thanks, Jenny. Thank you. There's a lot to be made of having a new procedure, especially one where we can be flexibly competitive. Do we have the permission in the title of the procedure to go to town with our creativity, though? And what does that mean in practice when we're sat with the palette of a contract strategy and the canvas that is our skeleton tender documents? How creative can you get? Well, compliance is still a requirement, and flexible doesn't mean maverick, but it can mean creative. It doesn't limit you from getting the most from your competitive, flexible procedure. If anything, that supports you to set a future path of least hassle and lessens the likelihood of challenge for yourself further down the line. So some points I want to just work through in developing your competitive, flexible procedure. Have you taken into account the change from meet to mat, which Jenny will tell us more about shortly? Have you considered the government innovation statement and what that means for your procedure? Have you taken into account and considered the objectives or the general principles described at section 12, delivering value for money, maximising public benefit, ensuring transparency, acting with integrity, and principles of equal treatment? Do be aware of what you need to take into account when you are creating your procedure. And in addressing those factors, be aware that you might have created something so weird, wonderful, and wacky, and make sure that you can still describe it. You don't want your masterpiece to be so nebulous that you aren't able to articulate it, because you will need to be able to. That is still very much necessary. And you need to be able to clearly articulate how you will be evaluating that. You will be expected and held to account to follow that process, including the way that you describe and apply your scoring criteria. So just keep these ideas that we already have in mind when you are trying to work up that flexible and creative ideas. Have you engaged with the market to make sure that they're capable of doing what your vision has inspired? Pre-market engagement is really important, particularly in a competitive, flexible process, to make sure that the design requirements and the threshold are all suitable. If they aren't, you're setting yourself up for a great deal of difficulty and not a lot of engagement. So do make sure that you are engaging in that pre-market engagement. Have you ensured that your timelines meet the minimum described in section 54 of the Procurement Act? And more importantly, that those timelines are reasonable to the procurement. You need to make sure that you're setting those with regard to the nature, complexity of the contract and the procurement documents. So if you've got something that needs thought by suppliers and needs consideration or needs engagement by bidders, third-party advisors, then you do need to be making, you do need, as you do now, but you do need to make sure where that process might be unfamiliar because you're using the competitive flexible procedure, that you've set timelines with enough space so that the bidders and their advisors can fully engage with those. And keep in mind whether or not there's a need to set out any subcontracting arrangements or site visits. All of these take time, and diary management is difficult at the best of times, let alone in a tender process timeline. Your tender notice must set out the process in full so that bidders understand just how your masterpiece is intended to work, including that assessment methodology. And not only that, but it's the place for showcasing what that vision is. It can be easy to forget that this is your profile advertising the world as to what a marvellous opportunity you have in this contract in order to attract bidders. Does your tender notice advertise you to the world as a good buyer, or is it scant, suggesting that the approach that the market can expect from you during the tender process is equally absent of effort and attention to detail? You're less likely to get engaged and enthusiastic bidders if they don't see that same level of commitment from yourselves in putting forward the opportunity. If you are using the process in a flexibly in a staged manner and don't yet have all the details to articulate your full process and methodology, then be aware that you are kicking that can and those difficulties for yourself down the road. And unless that is pinned down and articulated, it will come back to haunt you, more so now than under the existing regime. And Claire will explain where this might cause some regrets at the latter stages of the tender process shortly. Final suggestion from me is to look at those draft regulations. Have you spotted the obligations for a contracting authority to ensure that suppliers are registered on the central digital platform? Ensure that you're asking suppliers to upload their selection stage information, and forward plan for the supplier to be able to make representations explaining why it should remain in the process before excluding those suppliers. As Jenny's mentioned, those draft regulations are forthcoming, and they need to be read with a close eye when they are fully available. So just wrapping that up, as I've said, compliance is not the enemy of flexibility. It's there to enable you to embrace this opportunity. It gives a helpful and practical framework to navigate what might seem to some people quite daunting, given free rein to run amok potentially. And for those with ambitious procurement imaginations, it gives you and your teams the security and the support to work with those ideas. Thank you.
Thank you, Vic. That was fascinating. My question is around a topic, one of the features of the Act, which has caused a lot of interest. So this is the move from meet to MAT, and what does that mean in practice? So Regulation 6 to 7 currently in the PCRs, we've got the concept of the most economically advantageous tender. In section 19, we've got something called the most advantageous tender, and what, if anything, is the difference between those two. So if we look at section 19 in a little bit more detail, we can see that the most advantageous tender, the MAT tender, is the one that satisfies the requirements and best satisfies the award criteria. And you work out which one does that by reference to the assessment methodology, which is the new name for the scoring methodology, and also the relative importance of the criteria, what's most important to you. So those are the sort of pieces that go together to make up the MAT tender. So you can see the basics there, which is that the MAT tender must still satisfy the requirements that you stated, and it must still be the tender that scores highest. So there's no green light under MAT to effectively decouple the evaluation from the stated requirements or evaluation methodology. And of course, in the background, there are also the usual rules around setting award criteria. And I don't think these have changed in the Act particularly. They're set out at section 23, and that's the usual rules that we currently know and love, which say that our award criteria must be related to the subject matter of the contract, must be clear enough that bidders can understand what you mean, must be proportionate, etc., etc. So again, just because we've moved to MAT, there isn't any option to sort of introduce value-added criteria on the hoof or on the spur of the moment when inspiration comes to you. It's all got to be set out just as it does now. But having said that, there is a difference. The economic emphasis has been removed. So I think it is possible to set criteria which are aimed solely at non-price or non-cost elements. So what sort of areas could you include in a MAT assessment beyond quality and price, sort of escaping from the grip of quality and price into something different? And as Victoria said, the Act does have some new principles and new objectives, all of which seem to me that you could bring into a MAT assessment. So, for example, section 12 tells authorities that they must have regard to the fact that SMEs face barriers and whether the procurement could remove some of these barriers to SME participation. And also looking at section 13, which is the National Procurement Policy Statement. So this is going to be an ongoing statement of procurement policy, which will be updated from time to time with current priorities. So the current priorities track across to what we currently know in the social value model, for example. So creating new businesses, new jobs and skills, tackling climate change, improving supplier diversity, and a couple of objectives around managing commercial delivery and getting things set up so that value for money can properly be delivered. So I think one way to sort of really get creative with MAT is to really interrogate how you assess it. And this could be done as part of the creative process that Victoria was just talking about. Do you always have to refer to price in a value for money assessment, or is there a way that you can assess it on wholly non-cost elements? And it might be that as part of designing the CFP, this is something that you can think about and that you can test in pre-market engagement, for example. I think just it's fair to say that there are some challenges with using value-based criteria. Watch out for equal treatment problems. So any kind of criteria which gives a particular kind of supplier, such as an SME, an unfair advantage will be a problem. So you can see there's a conflict between the duty to remove barriers to SMEs on the one hand. All great if you can do that, but you can't do it at the expense of equal treatment. Linking to the subject matter of the contract and proportionality, those are sort of two similar points. So if your sort of value added requirements are disproportionate to the contract or are nothing to do with the contract, that would be a problem. So for example, you've got a commodity contract, but you try to get that supplier to offer apprenticeship schemes as part of that, that's going to be difficult. It would be different in a situation where this is a very large contract that's generating a lot of work for a supplier, where it might well be appropriate to ask for them to create job opportunities as part of that. And then finally, and this is often a tricky one, trying to write the evaluation methodology or apply it for value-added criteria. So the usual scoring tables probably won't work. Usually they work by referring to stated requirements and then assessing how well the response meets those. That may well not work for value-based criteria, and you may have to be a bit creative about how you draft the evaluation approach for value-based criteria. So hopefully that gives you a bit of food for thought on Meet to MAT. We're just going to look now, and I think Victoria's coming back again to talk to us about amending the procurement at the tender stage. Is there any flex to do that?
Yes, thank you, Jenny. And anybody who saw our earlier session on selection criteria might recognise this as a principle and some of these slides. That is deliberate, because while we hope you don't need or want to amend the procurement at tender stage, you may do so. And if so, what scope is there? Well, while there is a whole section 31 dealing with amending the procurement, we're somewhat of a mind that it is very similar to the existing position under the PCR. So recapping that, while the PCR isn't express about making amendments, if you're updating the award requirements, then we would be looking to the procurement principles under Regulation 18, principles of transparency, equal treatment, and non-disclosure. Non-discrimination, and ensuring those principles are met in what we do when we rewind the process and publish those new requirements to bidders, having taken a view of whether or not that is appropriate on a balance of risk. The Procurement Act is much more substantive in terms of giving some detailed guidance on when you may or may not make those amendments. Though between that section 31 and taking into account the general principles and objectives in section 12, in reality, how far does that really differ from what we have now? Move to the next slide, Jenny. In the case of an open procedure, you can modify your award criteria before the tender deadline, but that is not a carte blanche approach. And be aware of the principles, particularly I'm looking at C, sharing information for the purpose of allowing suppliers and others to understand the authority's procurement policies and decisions. It's very explicit that this needs to be clear, transparent, and disseminated, so that you can act and be seen to act with integrity. And that is limb D of those principles. Under the competitive flexible procedure, which is possibly where it's more likely, because if you have a staged approach and you may not have settled on what those later award criteria are, then this may be where it's most relevant. Got a line there as a reminder on the selection stage to be amended before that deadline for request to participate, but at tender stage, that key watershed line is the tender close date. So you may modify ahead of the tender deadline, but only if those changes are not substantial, a term that we'll be familiar with under the existing regime, and not where the process that you're running is a light touch regime. So do consider that substantial point carefully. Do the changes mean that another bidder would have otherwise engaged with the procurement as a whole in terms of the amendments that you've made? And then if you're satisfied that the amendment meets the requirements, what do you need to do? Notify suppliers. Consider amending those timelines so that they are still proportionate and appropriate to the procurement that we talked about earlier. And recommend republishing the tender notice and procurement documents that are affected by that amendment and any updated deadlines. And just because you can does not mean to say that you should. It is significantly better, of course, to get it right at the start and save yourself the hassle, the risk, and quite frankly, the extra work of having to deal with making amendments whilst you're in flight. And do be aware that rewinding and reissuing isn't a magic wave to clean it entirely of procurement risk. While it does mitigate risk, that can remain, and any updated criteria can amount to a breach of equal treatment and a breach of transparency. So just keep those points in mind.
So that's on to me next. And my question is, what is the impact of the Act on the evaluation and moderation phase of the tender? So I think a good starting point for consideration here is that much of what we currently know in terms of examples of good practice in conducting a successful evaluation and moderation process is derived from case law. And so whilst the case law follows those key procurement principles that we are very aware of, transparency, equal treatment and non-discrimination, those are set out in the regulations, but the practical examples and the practical application of those isn't actually set out in the regulations itself, and that instead is in case law. So that position is very much mirrored in the Procurement Act. And so in broad terms, the impact of the Act on the basic principles of evaluation and moderation isn't significant on first look. We don't have an awful lot more in terms of how authorities should go about undertaking a successful evaluation and moderation, and how to or how not to do that in practical terms. And so we are still likely to need to look at the case law for the practical application of our principles and duties in relation to carrying out those processes. And so the key cases in this area will continue to be highly relevant. There isn't enough time today to talk about those key cases in any detail. One of our previous 5 and 25 sessions does go into detail on evaluation and those key cases, and that's on our procurement portal website, if you do want to remind yourself of those. But an important point of note, I think, will be that we are, of course, going to be operating under a new legislative regime. And so that does give scope for the courts to interpret that legislative regime in a slightly different way. And we may get new precedents in certain areas. So it is, whilst those key cases are going to continue to be highly relevant in how we approach evaluation and moderation, we do need to watch this space for potential new judgments in areas where we see the application of the Procurement Act going forward. Next slide, please, Jenny. Thanks. So there are a couple of changes under the Procurement Act which we did want to highlight in terms of their potential impact on the evaluation and moderation phase of the tender, because they're the sort of elements where, you will realise at a later date that they were highly relevant to that process at that particular time. So it's good to think about these early. And the first of those is that increased flexibility in the designing of the procurement process, which Victoria was talking about earlier. And we've spoken about it quite a lot today, but it's just worth remembering that if you are creating a process that's perhaps novel or innovative in the way you design it, that you do still need to make sure that it can be effectively evaluated. So tracking that process through to how you're actually going to go about evaluating something that's potentially new and innovative is really important, because you don't want to get yourself into an issue later down the line if you come up with this fantastic new way of doing a process, but that you're actually then going to struggle, and people will struggle in understanding how you've gone about that process at a later date. So it's that point around flexibility isn't necessarily simplicity, and where you're doing something new or novel and people don't quite understand it, potentially it can create more risk in the process. So it's just being mindful of that going forward in terms of how that then affects evaluation and moderation later down the line. The second point that we wanted to sort of highlight in particular, I'm going to probably speak quite a bit about this in the next few minutes, is in relation to assessment summaries. So this is a new document under the Procurement Act, and it replaces what we currently now know as the standstill letter or the notice of award. It's the document in which you'll communicate the outcome of the procurement to bidders, and it will contain the debrief information that goes to bidders. So in the secondary legislation, we've got quite a prescribed list of information which now goes into the assessment summary. And when you look at that information, there are aspects of it which, if you get to the point of when you're actually drafting your assessment summary, there are certain pieces of information which need to go into that document, which will need to be considered and thought about and produced at the evaluation and moderation phase. So, for example, I've put a couple on the slide there. So 2 of the categories of information that are required to go into the assessment summary are the reasons why the tender was not given the score immediately above the score that they were actually given. And also where you've got a criteria that's split down into strands, you need to give the reasons and explanation as to why the tenderer was assessed against each of those particular strands. So the reason why they scored the score they did against each particular strand. So that's information that if you get to the assessment summary stage and you're drafting an assessment summary, if the evaluators haven't considered that during the course of the evaluation and moderation and recorded it in the notes, at the point at which you're drafting that document, you're going to draw a blank, or even worse, have to make up the information that goes in there. So you're really going to have some problems in that respect. And that's why it's really good to think ahead to ensure that evaluators and moderators are trained on this and that they're aware that these specific points need to be addressed and that their records need to record that discussion in relation to that so that you can meet the requirements of the assessment summary later. So next slide, Jenny. So this is me again. And the next question is what we need to be aware of in terms of the outcome of the procurement. And when we're communicating the outcome of the procurement, this is going to look slightly different under the Procurement Act. And as I've mentioned before, the assessment summary is the starting point for that. So this will contain similar but information to what we currently see under the standstill letter, but now it's quite prescribed and there's lots of additional parts that we need to consider in relation to that. And then the next phase following on from that is publishing a contract award notice. Now, it's worth noting this is one of those notices where we've had a bit of a change of name. So this isn't what we currently know as the contract award notice. This will be a document which we're expecting will follow, simply confirm that an assessment summary has been provided to bidders. And it's also an important document because it will trigger the start of that mandatory standstill period, if applicable. And the standstill period, another point of note, will look slightly different. So we now have an 8 working day standstill period as opposed to a 10 calendar day. So actually query whether there'll be a great deal of practical effect in that, but it is worth noting the change. And then ultimately, if that standstill, if that standstill period expires and the authority hasn't received any notification of any claim form having been issued, which we hope they wouldn't, then it can go ahead to proceed to enter into the contract with its selected winning bidder. Next slide, please, Jenny. So just to give you a little bit more detail on that assessment summary and some of the types of information that are contained within it. So we have essentially quite a prescribed list. And if you thought Regulation 86 was prescribed in terms of what needs to go into a standstill letter, what we have now in relation to assessment summaries is a lot more prescribed. But in some respects, it's very helpful because it actually gives a clearer example of the types of information which, going back and reflecting upon that case law that the courts have given us on a good and practical tips on conduct of an evaluation and moderation process, it starts to bring in some of those themes and almost forces authorities to start to give that information by complying with that prescribed list of information. So some of the things that we'll see in there are very familiar. We have the name, address, we've got unique identifier for the supplier now as well. And also sort of, we've seen the award criteria will be set out. We have a summary of the assessment methodology. This sort of new concept here that I've sort of mentioned previously, which is the scores awarded together with detailed reasons for those scores and the reasons why they haven't scored the score above, and where the criteria is split into strands, an explanation of how the tender is assessed against each of those strands. And that's going to be really key information going forward. And it's something that probably ought to be being done now, but this will really force authorities to sort of go down that route in terms of giving that information to bidders. And then what we have, and what is interesting in relation to this, where we have that list of prescribed information that goes into the assessment summary, authorities will then be required to create exactly the same list in terms of their winning bidder and provide that as well. So we have 2 essentially sets of information that can be reproduced, and they will both be provided as necessary to bidders. So interestingly, we no longer have that reference to the relative characteristics and advantages of the winning bidder, which anyone who's involved in looking at standstill letters or drafting standstill letters is a real bone of contention amongst bidders and authorities as to whether that obligation has actually been complied with. It's a rather strange obligation and it causes a lot of dispute because what it actually asks authorities to do is something which authorities shouldn't do in evaluation processes, and sort of essentially run in effect a comparative exercise between the winning bidder and an unsuccessful bidder. So it ends up being new information that's produced and then becomes contentious later down the line. And so this new process that's designed for the assessment summary, where you have two separate sets of information which stand alone by themselves, is likely to be far more straightforward in that respect, and therefore could prove a lot less contentious in terms of when we look at the information provided in those standstill letters.
Thank you,
That's
Claire.
it for me.
So I think it's just after 10:30, so it's time for us to finish today. Do let's have your feedback. A feedback form should pop up at the end. And as I said earlier, recording and the slides and also answers to questions will be circulated as soon as we can after the webinar. Do look out for our next one. I think we've got 25th of April for that, and we're going to be talking about framework agreements and dynamic markets. And at that point, hopefully, we will also have the new regulations, which will shine a light on those as well. So just remains to say thank you very much from Claire, from Victoria, and from me for joining us, and hope you all have a really lovely day. Thank you.